jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one.
Got it. Here's a tighter, polished rewrite of your text that keeps the punchy tone but makes it flow smoother.
2024, witness 1 stated that he observed the defendant arguing and then striking the complaining witness with a closed fist to her head. The complaining witness is the girlfriend of 5 years. The complaining witness fell to the ground and then the defendant hit her in the face again. Witness 2 tried to intervene, telling the complaining witness to run and then running into the Kroger asking for security. Once security was outside, the defendant threatened security to ignore what was going on and to mind their business. Witness 1 called the police and the complaining witness walked away from the scene. The defendant struck the complaining witness again with a closed fist to the head as she was walking off. The complaining witness stated the defendant was intoxicated and did not want the defendant to go to jail. The complaining witness admitted to the defendant striking her. However, she retracted her statement once the situation was likely leaning towards the defendant being in jail. The complaining witness does not want to pursue charges and refused to cooperate in regard to her injuries. Law enforcement officers observed bruising on her right cheek and neck area of her head. The complaining witness advised she would remain in contact with the defendant and
Did the judge just drop a jail threat and a metaphorical spanking in the same sentence? Welcome to a courtroom where consequences come with attitude. Humor aside, the point lands hard. Skipping school can derail your life fast, and this judge isn't buying excuses. Tough love or over the line? What's your take?
Lindsay and Edmund as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Threaten, harass, use another person to communicate a threat or harassing behavior. You can do none of this. No weapons or no going within 200 feet of where she lives or where she works. You understand? You violate these conditions, the state can and will file a violation of a protective order against you. As it stands now, Mr. Aris Mendez, no alcohol, no dope, and no contact. Otherwise, I'm going to put you in jail and I'm going to make your bond sky high. Do you understand me, sir?
Yeah.
Do you have any prior criminal history? The bond is set high for someone who, that's why, please, if you can run an NCIC, because the bond is higher than what normally would have, someone would have with no criminal history.
We can't speak on the bond decision, Your Honor, but with regards to this history.
Nothing? Okay. How old are you, sir? What do you do for a living?
Select that work at a warehouse.
How much money do you make a month? Who do you live with? Did you graduate from high school? Now we're going to start working on that. I will give you a lawyer today. You have 2 weeks to figure out how we're going to get started to work on getting your high school diploma. You must get online, start researching how to get your GED. I want you to do that. You come back in 2 weeks. If you've done nothing, life for you is not going to go well with me. You get my drift. You have 2 weeks to start researching how to get your GED, to get your high school diploma. You cannot walk around life without, at the minimum, having a high school diploma. You and I are going to work on that together. And if you don't, I will put you over my knee like a little child and I'm going to spank you with a ton of jail time. Do you understand?
Yeah.
So if you have any, let me ask you this. Do you have a computer? You don't have a computer. Okay. How do you access the internet? So you have a cell phone. Okay. Use your cell phone. And within 2 weeks, I want to see what you've done to register and look for classes. If you have any issues, I'm going to give you a lawyer today. And we have services that can help you if you need to get your high school diploma. We are going to do this one way or the other. It can either go the easy way or it can go the hard way. Do you understand? Okay. I already have an application on file. For now, I'm going to have you go to Victoria. We're going to have you sign a reset. After that, you'll get retraced for your bond conditions. No more dope, no more alcohol. Do you understand me? Okay. Come on.
Just so you know, Your Honor, he's 18 years long. He's here in the courtrooom. Do you want to run here?
Yeah.
I have an attorney, but I don't know where they are.
Yeah. They're always running late. Don't worry. I know them well.
Oh, right.
Good morning, Mom. Thank you for coming. You are, is it Lonan?
Yes, sir.
Lonan? Mr. Rushing, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On July 7th, 2024, officers were dispatched to an address regarding a suspicious vehicle and observed the vehicle stationary at a dead-end street. Officers asked the defendant what he was doing, and he said chilling and hanging out. Officers smelled a strong odor of burned marijuana emanating from the vehicle. Officers conducted a pat-down and located a THC pen in the defendant's pocket and a glass cylinder-shaped bottle with 5 white square pills that were Xanax. The defendant did not have a prescription bottle or prescription on him. It was 16 grams of Xanax.
So did they find a bunch of weed too, or any kind of weed, or?
No weed.
Mr. Rushing, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or dope, guess what happens? Right. Very good. Mom, I'm in your hands. Anything else you want me to do?
We're going to orientate. No, that's that.
Okay.
Is this just like probation?
Well, let's not, I'll let your lawyer handle what's going to happen as far as, I know, they're always running late. Don't worry about it. My only concern is I want to make sure that he's not using while he's out.
I have a test at home that I'm going to administer, and I'm going to start doing that right now.
Don't worry about it. I have a better test. And I'm telling you now, Mr. Rushing, 31 days from today, I'm going to test you for weed. If you test positive, that tells me that you've continued to smoke, and I will put you in jail.
Reminder, being in a relationship doesn't mean you own the other person. That kind of thinking is exactly why emergency protective orders exist. What would you do if someone said this to you? The defendant's response? White down pointing backhand index.
Using, likewise, you will go to jail. You will not get any more PR bonds. Perhaps it's a little jail that may cure him. You know, the problem is that you're now only 18. You're building your future. The more criminal cases you put on your background or on your record, the more difficult you just make it to get a job. And am I boring you, Mr. Rush?
Yes.
Look at your mom. Think it's easy on her?
I'm listening to you, sir. Like, absolutely.
Did you graduate from high school?
Yes.
What are you doing now?
I work at Pappy's Cafe. It's like a restaurant.
And yes, you have age orientation today.
Yeah, I have college orientation as well.
Where are you going to college?
Going to UH, University of Houston.
I graduated from there. It's a great school. The more you put into it, the better you're going to get, like anything in life. Okay. So if you find that he's become a problem to you, just come back, talk to me, and I'll straighten him out for you. Anything you need, really. You know, the problem is 18-year-olds, they act like they can rule the world. They know everything, but yet. So be careful. Don't pick up any new cases. Does he have a license? Okay. He has insurance, I suppose. Okay. I will waive your appearance so he doesn't have to mindlessly come back to court, but you just have to stay in touch with the lawyer, and then they'll tell you if and when you have to come back. For now, I'm going to have him sign a reset with Victoria. He's going to meet with Tracy for his bond conditions, and then we'll just have you waiting back for your lawyer. Okay? Yes, ma'am. Please. Mr. Smith, you're now charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 8th, 2024, the security manager at SATF advised that there was an altercation between 2 residents. The complaining witness advised that on July 1st, 2024, he was involved in a physical altercation with the defendant. The complaining witness said he was going down a hallway on his way to get a counselor's name for his own records, and as he was talking to the counselor, the defendant walked by and stated, "I would have him hit by now," to the counselor. The defendant struck the complaining witness in his left cheek with an open palm. The complaining witness felt pain and exited the altercation without retaliating. On July 6, 2024, the complaining witness threw iced coffee on the defendant due to an earlier assault. On July 8, 2024, while the complaining witness was sleeping, the defendant entered the dormitory and struck the complaining witness with closed fists on his face and back, and the complaining witness felt pain. The defendant admitted to the July 1st, 2024 strike and said that it was hot coffee on July 6, 2024, and said on July 8th, the complaining witness was present and awake and had been taunting him throughout the day.
Mr. Smith, I'm going to find that there's probable cause to go forward with the case. We took you into custody because you have a felony warrant. You're on probation for a 4 to 200 second-degree felony, and now they've issued a warrant. You're at no bond. So
So why is that? I was at the treatment facility. Oh, go ahead, finish. I'm sorry.
it's okay.
I was at the treatment facility and the roles were turned. He threw hot coffee in my face. And of course I reacted. So
Let you guys get down to that at a later time. I don't know. We will get all the evidence, and the evidence is going to point to whose story is correct because there's always two sides. I just don't know, and it's too early to find out. I wanted to let you know why we're taking you into custody, because you're on felony probation. You've now picked up this case. They've issued a warrant, and you're at no bond on that case now.
why is it no bond? I was at the treatment facility. It was mutual combat. Somebody hit you, you hit them back, and it's mutual combat.
I know that you're saying that, but
Yes,
how do I know if that's right? I don't know. I wasn't there. We got to figure out what happened, really, but I don't know. At this point, regardless, you've picked up a new case. And the other problem is there's only so many treatment facilities we have. I'm now barring you from going back to this treatment facility. I don't want you to accidentally run into this person.
Are you going to bar me?
Yes,
I'm doing excellent at that thing. There just because they got to keep harassing
certainly
me.
not.
You can call the people up there. They'll tell you. Kelly Doyle will tell you. I'm doing what I have.
I know Kelly well.
Please call her. She'll tell you. Kelly Doyle will tell you that she won't me back there.
Okay. For now, I'm ordering you now not to have any contact with the complaining witness,
How long?
not to be in possession of weapons. The problem is that if this person is still over there, I don't want you to accidentally bump into them. So regardless, it's the felony court that's going to send you to whichever facility that you're going to go to. I don't have any control over where you go to.
I was going to be done next month.
The other kicker is this, while this case is open anyways, you're not going to go to any facility until this case is over. So I will appoint you someone today. We'll figure out where we're going to go from here. And then at some point, we'll get you back into the facility. Or another equal.
Kelly, can you talk to Kelly, please?
But it's the felony court. I don't have any say over what the felony court does. It's the 228. You're in a good court, though. That's good news. So let's.
You're only 18. You're building your future. The judge delivers that truth bomb right before asking if he's boring the defendant. That tiny exchange speaks volumes about courtroom fatigue and frustration. But here's the bottom line. Youth doesn't erase consequences. These charges will follow you.